A court reporter named Marisol Vega certified a 47-page suppression hearing transcript on January 14, 2019. Cause number D1DC113044817. Travis County District Court. Hearing date January 14, 2019. Marisol Vega Certificate TXCR 29-00441. Marisol Vega died on November 9, 2018, 2 months before that transcript was certified. The filing attorney on the cover page. E-signature certificate TXATTY-24081776. That certificate belongs to me. I have never worked the Kellerman case. I was not in Austin that day. I practiced criminal defense in Texas for 29 years. Austin was my base. I opened a satellite office in San Antonio in 2011. DWI, assault, felony narcotics, 3 capital cases over the full run. I was not a famous lawyer. I was a thorough one. I read every file twice before I spoke to a client. I built my reputation on that kind of careful. I retired in the spring of 2023, closed the firm on March 31st, forwarded the phone, updated my bar status to inactive, handed the last client files to a colleague downtown. Then I drove home and sat in my kitchen for 3 hours not knowing what to do with my hands. The transcript showed up the following winter. My former paralegal, Denise Ochoa, had been with me for 11 years. She left 2 weeks before I closed the firm. No explanation. One Tuesday she was there. The following Monday she was gone. She had been efficient and loyal for a decade, and then she was simply done. I did not push. People leave. I was shutting down anyway. She mailed me a key in February. The envelope had a Cedar Park postmark. The note inside was 3 lines: storage unit, Cedar Park, Unit 114. She said the files there should be mine. I drove out in December 2023. The unit had 31 banker boxes. I had expected 23. The extra 8 did not register at first. I worked through the boxes I recognized, checking labels. Most were straightforward. Closed files, correspondence archives, billing records I should have shredded years ago. One box had nothing on the ends. I found it in the back corner, plain white banker box. The top flap had a case number written in black marker. D1DC 1934817 Kellerman. The writing was not mine. It was not Denise's either. She labeled everything in green ink, always. I set it on the concrete floor and opened it. Inside was a single bound document. Pale blue cover, Texas Judicial Council formatting, standard caption block, tabbed correctly, page numbers centered at the bottom of every page. State of Texas, plaintiff, Riordan Kellerman, defendant. 299th Judicial District Court, Travis County, Texas. Cause number D1DC-19-304817. Motion to suppress evidentiary hearing transcript. Date of proceedings, January 14, 2019. Total pages 47. The transcript looked completely standard on a first pass. Double-spaced colloquy, exhibit references in the margins in the correct format, witness testimony indented properly, page numbers clean. I have read hundreds of hearing transcripts over 3 decades. The formatting tells you immediately whether something is legitimate. This was legitimate. Every convention correct, every notation in the right place. At the end of the document, the court reporter's certification ran 2 paragraphs, standard language. I, the undersigned, certified court reporter for the state of Texas, do hereby certify that the foregoing is a true, accurate, and complete transcript of all proceedings had in the above captioned matter on the date indicated. Marisol Vega. Certificate TXCR 201-00441. Below her printed name, a signature in wet ink, not a scan. The ink impression was slightly raised at the edges, the way wet signatures are when the paper is pressed before the ink is fully dry. Date, January 14, 2019. I sat in the storage unit with the transcript in my lap for a while. The fluorescent overhead was humming. A car moved past on the access road outside. I pulled out my phone and opened my case management system. I searched for Kellerman. Nothing. I searched the cause number. Nothing. I searched the 299th District Court's docket, filtered to my firm name. No Kellerman file. I put the transcript in the passenger seat and drove back to Austin, intending to call the Travis County District Clerk in the morning to figure out where it had come from. That night I read through it more carefully. The hearing concerned a motion to suppress evidence from a warrantless vehicle search. The defense had filed the motion arguing that a confidential informant's tip did not establish adequate probable cause, and that therefore the subsequent search of the defendant's pickup truck violated the Fourth Amendment. The state argued exigent circumstances. The judge ruled in favor of the defense. The suppression motion was granted. State's Exhibit 14, described in the transcript as a forensic laboratory analysis of controlled substances seized during the search, was excluded from the evidentiary record. Standard outcome. I have argued that fact pattern 50 times. I was about to set the transcript down when I noticed the judge's name. Honor Patricia Sandoval Hirsch. I know Judge Sandoval Hirsch. I appeared before her at least 15 times between 2007 and 2019. She is deliberate, careful, methodical. She runs a clean courtroom. She does not hold surprise hearings. I called her clerk the next morning. I said I had come across a transcript from the 299th's January 14, 2019 docket and was trying to confirm its provenance. The clerk pulled the calendar. She said the judge had no hearings that day. She said Judge Sandoval Hirsch had been out of county at the 14th Annual Texas Judicial Leadership Conference in Dallas. She had delivered remarks on Thursday morning. Thursday, January 14, 2019. I asked her to search the case system for the cause number regardless. She went quiet for about 30 seconds. Then she said, "The case is in the system. The transcript is filed." January 16, 2019. 9:12 a.m. I asked who the filing attorney of record was. She read me a name, my name. Then she asked who was calling. I told her. The line went quiet for several seconds. She said she would need to call me back. That was 14 months ago. When I got off the phone, I went back to the cover page and found the electronic filing block. Every e-submitted document in the Texas court system has one. It records the filing date and time, the submitting attorney's name, and their e-signature certificate number. The block read, filed via e-file Texas, January 16, 2019, 9:12 a.m. Attorney of record, my name, full, correct middle initial, e-signature certificate number, TX.2401776. I stared at that number for a while. TX.8240876 is my certificate. I have held it since January 2016, when the Texas courts moved to mandatory electronic filing. I activated it myself through DocuSign Legal Trust, linked to my Texas Bar membership. I have used it on hundreds of filings. It is mine the way my bar card is mine. I was not in Austin on January 16, 2019. I was in San Antonio for 3 days around that date. Continuing legal education seminar at the Marriott on South Flores, January 15th through January 17th. I checked my email archives that evening. The hotel confirmation was still there. I filed nothing during those 3 days. I had a junior associate handling anything urgent in my absence. That evening, I typed Marisol Vega, court reporter, Austin, Texas, into my browser. Her professional website came up first. Freelance certified reporter serving Travis, Williamson, and Hayes counties. 8 years in practice. The site listed her areas of specialty: criminal proceedings, civil depositions, arbitration hearings. The page had last been updated in October 2018. Then I searched the Austin American-Statesman archives, November 14, 2018. The obituary was 5 paragraphs. Marisol Elena Vega, 34 years old, of Austin, died November 9, 2018, following injuries sustained in a multi-vehicle accident on Interstate 35 southbound. She was survived by her sister Delia Vega of Austin and her brother Tomas Vega of San Marcos. 66 days before the transcript she certified. I called the Texas Court Reporters Certification Board the following morning. I gave them the certificate number TXCR 290041. The staff member confirmed it was issued January 12, 2017, to Marisol Elena Vega. She said the certificate was valid through January 2020. I asked the current status. She said, active. I asked if there was a process for reporting a certificate used after the holder's death. She put me on hold for 4 minutes. When she came back, she said she would need to escalate the inquiry and would take my contact information. No one has called me from the certification board. That was 13 months ago. 3 days later, I received the full public file on the Kellerman case from the Travis County District Clerk. I read it from the first page. Riordan Kellerman, arrested March 4, 2016, charged with distribution of a controlled substance, felony of the first degree. Defense counsel at intake, David Mendez, Travis County Public Defender's Office. The case moved through preliminary hearings, discovery, and plea negotiations over 18 months. I turned to the disposition page. Guilty plea entered, September 11, 2017. Sentenced to 8 years, suspended with 5 years of supervised probation. Riordan Kellerman had entered his guilty plea 16 months before the suppression hearing described in the transcript. The hearing in the transcript adjudicated evidence in a case that had already been fully resolved. The suppression motion in the transcript was filed to protect a defendant who had already pled guilty and gone home. A transcript certified by a dead court reporter. A hearing that took place after the case it belonged to was already closed. Filed under my e-signature while I was in San Antonio. I want to explain what I found when I started checking each of those things separately. Each one made it worse. I submitted a public information request to Travis County for the building access logs for the Travis County Justice Center on January 14, 2019. Texas has broad public information law. For a facility like the Justice Center, the electronic badge access logs are generally available. It took 8 days to receive the response. Room 4C is where the 299th Judicial District Court holds its proceedings. The access log for January 14, 2019 showed 3 badge scans in the building before 7 a.m., 2 maintenance staff and 1 security guard. After 7 a.m., Room 4C showed 0 badge activity, 0 entries, 0 exits, all day. The courtroom was not opened on January 14, 2019. For context, in Texas district courts, every hearing generates a physical record. The bailiff checks in, the court reporter badges through the secured access point on the 3rd floor. Defense counsel and prosecution badge through the same checkpoint. The defendant is escorted in. There is no way to hold a suppression hearing without at least 5 separate badge scans in and out of that courtroom. On January 14, 2019, not one person entered Room 4C. I found the assigned bailiff through the Travis County Sheriff's Department employee roster, Deputy Harlan Pruitt. I emailed him. He wrote back the same day. He said he had no memory of any proceedings in Room 4C on January 14, 2019. He said the room would have been dark that week. Dark is the courthouse term for a courtroom with no scheduled proceedings. He said he had been reassigned to cover Room 2A that week because 4C was out of rotation. He said Room 4C was dark the entire week of January 14th. The judicial conference was easy to confirm. The Texas Office of Court Administration maintains public records of all official judicial events. The 14th Annual Texas Judicial Leadership Conference was held at the Adolphus Hotel in Dallas, January 13th through January 16th, 2019. Judge Patricia Sandoval Hirsch is listed as a presenter in the conference program. Her name appears in the official attendee roster. Her hotel reservation was booked through the OCA's judicial travel account. She checked out on January 17th. She was 4 hours north of Austin. For the entire period, the transcript says she presided over a hearing in her own courtroom. Her verified electronic signature is on page 1 of the transcript. The transcript records her ruling from the bench, her colloquy with counsel, and her final order granting the suppression motion. None of that happened. Now I want to talk about what is inside the transcript itself, because the content does not track with the Kellerman case record. The hearing in the transcript centered on State's Exhibit 14. The transcript describes it as a forensic laboratory analysis of controlled substances recovered from the defendant's truck during the warrantless search. I pulled the full Kellerman public file and went through every exhibit list, every discovery disclosure, every filing. There is no State's Exhibit 14 in the Kellerman case. The Kellerman file contains 11 State's exhibits. The highest numbered is State's 11. State's 14 does not exist in that file. It has never existed in that file. The transcript also referenced testimony from a confidential informant, identified in the transcript by the initials CW. The defense motion challenged the CI's reliability and the adequacy of the probable cause determination. I went through the Kellerman discovery disclosures 3 times. No confidential informant is mentioned anywhere, not by initials, not by general description, not in any law enforcement report. The probable cause for the vehicle search in the actual Kellerman arrest report was based on direct officer observation, not a CI tip. The suppression hearing in the transcript was litigating evidence that does not exist in the case it is supposed to belong to. It was not an anomalous filing in the Kellerman case. It was a complete fabrication that happened to be filed under the Kellerman case number. Then I found page 31. Page 31 contains a standard colloquy where the judge asks defense counsel to confirm their appearance for the record. In the Kellerman file, the attorney of record for the defense was David Mendez of the Travis County Public Defender's Office. He handled the case from intake through the guilty plea in September 2017. There was no substitution of counsel. No private defense attorney was ever entered as appearing counsel. Page 31 of the transcript reads, "Defense counsel, please state your appearance for the record." The response is my name, my full name, correct middle initial, stated for the record, followed by the judge saying, "Thank you, counsel, please proceed." No substitution of counsel form, no court order authorizing my appearance, no conflict check in the Kellerman file with my firm name, just my name in a transcript in a room that was locked for a case that was already closed. I decided to run a comprehensive search on my e-signature certificate in the Texas e-file system. I submitted a written inquiry to the State Bar of Texas Authentication Office. 6 days later, I received a written response. The response confirmed that Certificate TX 8TWAT2408176 had been used to submit filings on the following additional dates in cases where my firm of record was not the filing entity of record. First, March 4, 2019. State of Texas v. Armando Delgado, Travis County. A motion to suppress evidence from a residential search, filed under my certificate at 2:17 p.m. Second, April 29, 2019. State of Texas v. Carolyn May Burtis, Williamson County. An emergency motion for bond reduction, filed under my certificate at 9:44 a.m. Third, August 14, 2019. State of Texas v. Marcus Trevino, Travis County. A motion to dismiss for prosecutorial misconduct, filed under my certificate at 11:03 a.m. 4th, November 3rd, 2019. State of Texas vs. Priya Nair, Hays County. A motion to exclude expert testimony, filed under my certificate at 4:31 p.m. I checked all 4 names in my case management system. Nothing. I searched the cause numbers. Nothing. I have never appeared in any of those courts in those cases. Then I checked the outcomes. In the Delgado case, the suppression motion was granted 2 weeks after filing. Evidence excluded. The prosecution moved to dismiss for insufficient remaining evidence. Case closed. In the Burtis case, the bond reduction was granted. Carolyn May Burtis was released from Williamson County Jail on May 2, 2019. In the Trevino case, the motion to dismiss was granted on August 28, 2019. The judge found prosecutorial misconduct based on the filings submitted under my certificate. Marcus Trevino walked out of the Travis County Jail that same afternoon. In the Nair case, the motion to exclude expert testimony was granted. Without the expert, the prosecution's theory of the case collapsed. Charges were dropped on December 3, 2019. 4 cases. 4 successful defense motions filed under my name. 4 defendants released or cleared. Each motion was accompanied by a certified hearing transcript. In each case, when I cross-referenced the transcript date with the courtroom access logs I subsequently requested, the records showed no badge activity in the assigned courtroom. 4 hearings, 4 courtrooms, 4 days with no entry records. I spent an afternoon in San Antonio going through my email archives from January through November 2019. I was using eFile Texas continuously throughout that period. I filed dozens of documents in my own cases. I have the filing confirmations in my sent folder. My certificate was simultaneously being used by someone else. Same system, same certificate number, same authentication credentials. I called DocuSign Legal Trust, the company that manages the State Bar's attorney certificate infrastructure. They were cooperative at first. They pulled the activity log for certificate TX8TY-2401776. For each of the 5 filings in question, the log showed an originating IP address. All 5 addresses resolved to locations in the Austin metropolitan area. On January 16, 2019, the Kellerman transcript filing, I was at the Marriott on South Floors in San Antonio. On March 4, 2019, the Delgado motion, my calendar shows a client meeting in my San Antonio office at 2 p.m. On April 29, 2019, the Burtis motion, I was at a deposition in Bexar County that ran from 9 a.m. to noon. On August 14, 2019, the Trevino motion, I have a gas receipt from a station on I-10 west of San Antonio, timestamp 10:47 a.m. Every single filing that appeared under my certificate in cases I did not recognize was submitted from Austin. On every one of those dates, I was in San Antonio. The e-filing system requires 2-factor authentication. To submit under a certificate, you need the credentials and a one-time token sent to the registered email or phone on record. The registered email for TX@TY2408176 was mine, my personal account. I reviewed the email logs. No one-time tokens were delivered to my inbox on any of those dates. Whoever was using my certificate was not generating authentication tokens through my email. They were getting them some other way, or the tokens were not being required at all. I do not know which of those explanations is worse. I submitted a formal complaint to the State Bar of Texas in March 2024. I documented all 5 cases, the dates, the IP discrepancies, the certified transcripts, the dead court reporter, the authentication anomalies in the DocuSign logs. I attached copies of everything and sent it by certified mail to the Office of Chief Disciplinary Counsel. 6 weeks later, I received a response. 2 paragraphs. The State Bar's letter stated that Certificate TXATY 24081776 showed no record of unauthorized use. It stated that all filings associated with the certificate carried valid authentication tokens, and that the e-file Texas system logs showed no security anomalies flagged during the relevant period. It stated the matter was closed. I sent a letter back requesting the specific log data they had reviewed. I asked what threshold was used to define no anomaly. I asked whether they had cross-referenced the filing IP addresses with the certificate holder's known location. I did not receive a response to that letter. I went back to the Kellerman case. I wanted to know if anything had been added to the file after the 2019 transcript was filed. The transcript had appeared in the public record. Something must have followed it. The Travis County District Clerk's online portal showed the case status as sealed. Date sealed, August 12, 2021. Reason, Administrative Review, Order 9D. I looked up Order 9D of the Texas Rules of Judicial Administration. It does not exist. There are 9 orders in the Texas Rules of Judicial Administration. None is designated 9D. The numbering system does not work that way. Order 9D is not a real administrative authority. Someone sealed the Kellerman file under a citation that cannot be verified because the order it cites does not exist. I called the district clerk's office and asked for clarification. The clerk said she could not discuss a sealed case. I told her I was not asking about the contents. I was asking what administrative authority authorized the sealing. She said she would need to transfer me to the presiding judge's office. I was transferred. I left a voicemail for the court administrator. No one called back. I found Marisol Vega's sister through the obituary. Her name was listed there, Delia Vega of Austin. It took me 2 weeks to find a working phone number. When I reached her, I explained who I was and what I had found. I said I was a retired attorney looking into a certified transcript that bore her sister's credentials and date. She was quiet for a moment. Then she said someone else had already asked her about this. I asked who. She said she did not know his name. A man. He had come to her house in February 2022. He said he was from a county court administrator's office. He asked about Marisol's last few weeks of work. He asked if any of her professional equipment had been recovered after the accident. Delia said he was polite and took notes and left after about 40 minutes. She never saw credentials. She never confirmed he was who he said he was. I asked about Marisol's work schedule in October and November 2018. Delia said Marisol had not been working since late October. She had undergone wrist surgery on October 31, 2018, a procedure to repair damage from a repetitive strain injury that had been getting worse since the summer. Stenographic transcription requires full and controlled use of both hands on a steno machine. After the surgery, Marisol could not operate her equipment. She had told Delia she would be out for at least 3 months. She never recovered. The accident happened 9 days after the surgery. Delia said Marisol's steno equipment, her work laptop, and her certification documents had all been inventoried and accounted for as part of the estate. The laptop had been kept for several months before the family wiped it. But before it was wiped, Delia's brother Thomas had checked the remote access log. 3 access sessions after Marisol's death: November 27, 2018, December 4, 2018, January 3, 2019. Someone had been using Marisol Vega's professional laptop during the weeks leading up to the January 14th transcript date. Marcus Trevino. I want to say his name clearly, because he is not an abstraction. Marcus Trevino was arrested in June 2019 on charges of aggravated assault and was in the Travis County Jail awaiting trial when the motion filed under my certificate was submitted in August 2019. The motion to dismiss for prosecutorial misconduct was granted on August 28, 2019. Marcus Trevino walked out of jail that afternoon. On February 14, 2020, he was arrested again. Aggravated assault with a deadly weapon. A woman named Soraya Fuentes was hospitalized with serious injuries. She recovered. Trevino entered a guilty plea in October 2020 and received 12 years in state prison. I do not know what would have happened to Trevino's 2019 case if it had proceeded normally. I do not know if the prosecution would have prevailed. I know that the document that ended his case in August 2019 was filed under my name by someone who was not me, in a hearing that never took place, certified by a woman who was already buried. I know that Soraya Fuentes was attacked 6 months later. That fact does not leave me alone. On the morning of February 3, 2024, a plain envelope arrived at my house. No return address, Austin postmark. Standard letter envelope, slightly thicker than usual. Inside was a single page, printed, not handwritten, clean formatting, court caption at the top. State of Texas v. Riordan Kellerman, cause no D1 DC 19-34817. Below the caption, transcript continuation, January 14, 2019, page 48 of 48. My transcript had 47 pages. This was page 48. I read it twice before I was able to fully process what I was looking at. The page was a colloquy, a formal exchange between the judge and the appearing defense counsel, conducted after the suppression ruling had been entered. The judge was asking counsel to confirm their understanding of the implications of the sealed record and the effect of the ruling on future proceedings in related matters. The attorney's responses were formal and careful. The language was measured, the way you speak when you know everything is on the record. At line 4 on the page, the judge said, "Counsel, do you understand the full consequence of this filing for proceedings that have not yet been initiated?" The attorney said, "Yes, Your Honor, I understand fully." The judge said, "And you filed this motion of your own accord?" The attorney said, "I filed it because I was asked to." The attorney speaking those words was identified in the caption block at the top of the page. Appearing defense counsel, my name, full, correct middle initial. I did not write those words. I have no memory of standing in that courtroom. I have no memory of anyone asking me to file anything in the Kellerman case. I have no memory of the Kellerman case at all, beyond the transcript that appeared in a storage unit in December 2023. And yet there is my name on page 48 saying I filed it because I was asked to. I drove to Austin that afternoon. I walked into the Travis County Justice Center and approached the public counter in the district clerk's office. I asked the clerk to pull the public docket sheet for cause number D1-DC-19-304-817. Just the docket sheet. The case was sealed. I understood that. I was not asking for the contents. She typed for a few seconds. She said she could give me the public docket index. She printed it and slid it across the counter. The index showed the total page count of the filed record. Not 47, not 48, 49. Page 49 had been filed January 21st, 2024, 18 days before I was standing at that counter. The filing attorney of record was my name, my e-signature certificate, TXATY 2408176, filed 3 weeks before I knew page 48 existed. Marisol Vega certified 47 pages of a hearing she attended 2 months after she was buried. That line has been sitting in my head for months now, because it sounds like the worst of it, and I understand why. A dead woman's credentials used to certify a fake hearing. That is a crime. It has explanations. Bad ones, but real ones. Someone accessed her laptop. Someone forged her wet signature. Someone reconstructed her certification seal closely enough that it passed every visual check. Those are things that can be investigated, things that have a boundary. But my certificate does not have a clean explanation. I did not give anyone access to my credentials. I did not share my two-factor authentication. I was not in Austin on any of those dates, and yet the logs show valid authentication tokens. The bar says no anomalies. DocuSign says the sessions were clean. 5 filings in 5 cases I have never touched. 4 defendants released through hearings that did not happen. A court reporter's dead credentials used to certify every one of them, and in every document, my name, my certificate, my full name stated for the record, in a locked room before a judge who was in Dallas. I have not spoken publicly about this before now. I sent a second formal letter to the bar after page 48 arrived. I sent a preservation demand to DocuSign Legal Trust. I have received no response from either. I submitted a records request for page 49. The clerk's office confirmed the page exists. It confirmed the filing date and the certificate used. They cannot release the contents because the case is sealed. Whatever is on page 49, it was filed under my certificate 3 weeks before I was standing in that office. I do not know what it says. I do not know who filed it. If you have worked in the Texas court system or if you have encountered certificate TXCR 2019-0044 or 481776 on any document in any capacity, I want to know. That's why I'm recording this, because page